I couldn't tell, you know. So I'm actually glad this many of you are here. Often the spring break, the last class is often dwindling attendance. I'm glad you're here, but this is an important class. So first, before we begin, any questions on the 14th Amendment? Any question on the 11th Amendment? Any questions on the enforcement power of Congress under Section 5? Any questions at all on Chisholm v. Georgia or sovereign immunity? Anything you want to ask me about? No? Okay, let's start. So for today, we begin our topic on the 14th Amendment and equal protection. And we'll do this for a couple classes. We've already discussed with the 14th Amendment that the court effectively disregarded one of its key provisions, the Privileges or Immunities Clause in the slaughterhouse cases. The court basically ignored it. They read it out of the Constitution. The court also, in the civil rights cases, read the Section 5 power very narrowly. You'll recall that the court held that only state action can be regulated by Congress and not private action. And you may remember there was a dissent by Justice Harlan. And Justice Harlan said, wait a minute, there are these badges and incidents of slavery, right, under the 13th Amendment. And the mere fact that you make someone not a slave doesn't eliminate the fact that there's still reminders of slavery, one of which is segregation in public accommodation places. So the court read narrowly the Privileges and Immunities Clause. They read narrowly the Equal Protection Clause. They read narrowly Section 5. They even read narrowly the 13th Amendment, which defines how Congress can eliminate slavery. Our discussion today focuses on two cases on both sides of the 14th Amendment that yield results that are somewhat congruent. We begin with Dred Scott, a case which I'm sure you've all heard of before. Dred Scott was a decision that said nothing in the Constitution at all provides that people of African descent are citizens, or even people for that matter, entitled to any rights. Then came the Civil War. Then came the 14th Amendment. And then nearly 2 or 3 decades later, we had the case of Plessy versus Ferguson. And you would have thought that after Dred Scott, after the Civil War, after the 14th Amendment, perhaps the Supreme Court would have found that a segregated train car, by the way, the train cars were considered common carriers, they're public accommodations, they're basically government service, that the law mandating segregated train cars would not be okay. Indeed, the court did not. So what we saw in the decades after the 14th Amendment's ratification is the court systematically, narrowly construed each of the provisions, privileges or immunities, Section 5, equal protection, 13th Amendment. They narrowly construed these in ways to provide very little protection for perhaps how they were designed to operate. So I always like teaching this juxtaposition of Dred Scott back to back with Plessy. It's not always taught that, but I like doing the juxtaposition back to back. So you can see how basically the entire 19th century was consummated with this issue. And the resolution in Plessy didn't quite resolve anything and only paved the way for what would come not even 5 decades later in Brown v. Board of Education and in several cases thereafter. So any questions on the outset? All right, so let's start. So we have to actually begin, before we talk about Dred Scott, we have to talk about Thomas Jefferson and the Louisiana Purchase. One of the first discussions we had in this class was when we asked, let me find the map, was when we asked, who is responsible for interpreting the Constitution? And I'm sure all of you thought before you came to law school, the courts. And that is not the only answer. Indeed, each branch of government, executive, legislative, they take an oath to the same Constitution the judges do. And nothing John Marshall said to the contrary The courts don't have a monopoly in interpreting the Constitution. That's a lesson we'll see very well for Dred Scott. So one of the first tests of this was the Louisiana Purchase. President Jefferson was given an amazing opportunity. Napoleon Bonaparte, who at the time was the dictator of France, offered to sell to the United States what were known as the Louisiana Territory. I mean, Louisiana is, it's a little boot down here, but it basically stretched all the way up, right? King Louis, that's why it's called Louisiana. Learned something. I hope you didn't learn that, but if you did, good. So Jefferson and his emissaries, Robert Livingston and James Monroe, were given the chance to buy this now. Under the Constitution, we have a clause, right? We have a clause for the acquisition of property, okay? And it belongs to Congress and not the president. So had Congress passed a law providing for the acquisition of this new land, no big deal. But the problem was Jefferson didn't have time to get a statute, right? This was a deal that made once and they had to execute it. And Jefferson said, okay, we're going to buy it. We're going to buy Louisiana Territory. Jefferson had doubts if he could even do this. And he even later wrote in letters that according to a strict construction of the Constitution, you can't. But then Jefferson wrote something. I want you to pay careful attention to his words. He said, a strict observance of the written law is doubtless one of the high duties of a citizen, but it is not the highest. The laws of necessity, think about that, the laws of necessity, of self-preservation, of saving our countrymen in danger, are of higher obligation than adhering to the written law. To lose our country by a scrupulous adherence to the written law would be to lose the law itself, with life, liberty, and property, and all those who are enjoying them with us, thus absurdly sacrificing the ends to the means. I mean, think about what Jefferson's saying there, right? Just dwell on that for a moment. He says, yes, following the law strictly, that's important, right? But Jefferson says, but more important is necessity. Okay, so who gets to decide what necessity is? That when Truman decides to seize the steel mills, was that necessity? Was that when Roosevelt decided to put Japanese Americans into internment camps? Was that necessity? So this was, before we even have this idea of separation of powers that's been so developed. But Jefferson, who was pretty instrumental in the founding of our country, had these beliefs. But he did it anyway, and we can put aside whether it's constitutional or not. Congress actually ratified it. In other words, Congress passed a statute after the fact saying, yes, we are acquiring Louisiana. At that point, it was moot. It didn't matter. But Congress ratified the action. Okay? But a key component, though, of the fact that Jefferson acquired it himself was that he put no limitations on slavery. You see, when the legislator had acquired other territories, the Northwest Territories was basically modern-day Ohio and Michigan and Minnesota. They had made the territories in Michigan, Ohio, Minnesota free, no slavery. But Jefferson, because he acquired it unilaterally, made no reservation about slavery. And as a consequence, in the Louisiana Territory, slavery was permitted. And this gave rage. This gave way to perhaps the most significant political debate of the early years of the Republic. I mean, we talked about the National Bank. That was small fries in comparison to this. Because as the United States expanded westward, right, as the U.S. expanded westward, every new territory that became a state, the controversy was, would this be a free state or would this be a slave state? And the reason why this was so significant was that every slave state would send 2 more pro-slavery senators to the Senate. Every pro-slave state would send another representative to Congress. What's the consequence of that? It will be harder to repeal the slave trade. Remember, the slave trade cannot be eliminated, right? Until I'll show you the clause. Until 1808. Okay, it was eliminated, right? But every single slave state you add gives a stronger share in Washington to the pro-slavery movement. As well, it stacks the Electoral College. The Electoral College is made up of the number of senators and representatives per each state. So the more slave states there were, the more likely it is that there'll be a pro-slavery president elected. Indeed, I think this is in your notes that virtually all the first, 8 or 9 presidents, except for a couple, were all from Virginia. They were all slaveholders. That was not an accident because of the way the Electoral College was stacked. So in 1820, Congress reached what was known as the Missouri Compromise. What the Missouri Compromise did was it admitted Maine as a free state, Maine all the way tippy top up here, it's in Canada, right? And Missouri, the show me state, as a slave state. And it said, going forward, anything above that green line, at the 36th parallel, would be free, and any new states below that green line would be slave. And this was meant as an effort to try to balance out the country, right? But this compromise did almost nothing to resolve the sectional conflicts that were hurtling together leading up to the 1850s. There was this long battle over how to deal with these. Okay. And that brings us to the Dred Scott decision. You can read Dred Scott almost like an onion. I suppose it makes you cry at each layer, but there's many layers in Dred Scott. And each time you peel back one, grab a few tears, there's another one underneath. Ostensibly the case, and I mentioned this a few weeks ago to make you laugh, but ostensibly the case was about diversity of jurisdiction, right? This is probably surprising. We read this like, this is about CIFPRA? What am I reading this? At the top, the top layer of the onion, right? It was about diversity of jurisdiction. But beneath that, there was a question of if indeed you are a citizen, are you entitled to the rights of being a citizen? And beneath that, if indeed you are a citizen, that means you cannot be a slave. What does that do to the property rights of the master who owns you? And beneath that was yet another layer. Did the federal government even have the power in these territories out west to deprive the masters and establish a slavery-free zone, right? There's so many layers to this case, which is why it's a fairly long excerpt, but I think the excerpt does it, gets a good job. So I want to talk a little bit about the facts leading up to this case. So this is the portrait of Chief Justice Roger Taney that most people are familiar with. He was the Chief Justice after John Marshall. Imagine trying to follow that up, right? He was the Chief Justice after John Marshall. And he was from Maryland, in fact. He was the only justice from Maryland. If you check Wikipedia, they're wrong. It says John Roberts from Maryland. He was not. He was from Buffalo. Someone said that recently. I got upset. No, John Roberts from Buffalo. He's the only justice from Maryland. Roberts was born in Buffalo. He grew up in Indiana. So this is Taney, and indeed, here's his bust. If any of you were watching Justice Scalia's memorial a few weeks ago, you saw the bust of Roger Taney right behind him. It was an interesting juxtaposition. I think based on the seniority, I think Sotomayor was standing right in front of the Taney bust. And indeed, there's a movement abroad on many campuses and grounds of taking down statues. So, for example, at UT Austin, in the last year or so, there was a statue of Jefferson Davis, the President of the Confederacy, and was recently removed. In Frederick, Maryland, which was the hometown of Roger Taney, recently someone dumped a bucket of red paint on his bust, and there's currently a movement to eliminate eliminate Roger Taney. They want to replace him with Frederick Douglass, which would be a different story. But but they're trying to remove various aspects of history, which is why I go back to the Supreme Court and I see the Roger Taney bust. I'm suspecting at some point there'll be a movement at the Supreme Court to get rid of the Taney bust, saying he should not be in the Great Hall of Justice as you walk to the court. So it'll happen. You'll say I'm right, but trust me, it'll happen at some point. But going to Taney, I want to show you this picture of him. Okay, it's hard to see. I know it's very small. This is the only picture I could find. But this is actually a portrait of Taney much later in life. He was 82 in this. The picture I showed you a moment ago. He was younger. He was in his vibrancy, but here he was 82. And the reason why I like showing this picture is because of a dissent you'll read from Justice Scalia. In a couple weeks, you'll read a dissent from Justice Scalia in a case called Planned Parenthood versus Casey. This was a significant abortion decision from 1991 or 92. And in the decision, Justice Scalia makes a charge. Scalia says that we as a court have no business trying to resolve the moral issue of abortion. Right? We have no business here doing this. And Scalia draws an analogy between abortion and slavery. And he's trying to say, in the same respect that Taney thought he could resolve the issue of slavery by a decision of the Supreme Court, neither can the Supreme Court resolve this issue of abortion, right? Court decisions don't change culture. So Scalia wrote, and let me read this one. He is in all black, sitting in a shadowed red armchair, left hand on a pad of paper in his lap, right hand hanging limply, almost lifelessly, beside the inner arm of the chair. He sits facing the viewer and staring straight out. There seems to be on his face and in his deep-set eyes an expression of profound sadness and disillusionment. Perhaps he always looked that way, even when dwelling upon the happiest of thoughts. But those of us who know the luster of the great Chief Justiceship came to be eclipsed by Dred Scott cannot be helped believing that he had that case. Okay. I expect that. Hold on. Oh, did I script this quote? But for those of us who knew the luster of his great Chief Justiceship came to be eclipsed by Dred Scott cannot help believing that he had that case. It's already apparent consequence for the court, and it seems to be played out consequence for the nation, burning on his mind. Scalia was saying the reason why Taney was so sad was his recognition that his attempt to save the nation from slavery failed miserably. Okay. Scalia continues by foreclosing. I'm sorry, let me read the last paragraph. So it's a long quote. I'm going to try and keep it short. He says, "We should get out of this area we have no right to be. And we do neither ourselves nor this country any good by remaining." One of the things you have to understand about the Dred Scott decision, what it was an effort to try to resolve this massive social and political dispute, and it backfired immensely. The book discusses, right, how Taney sought to avert a civil war by effectively saying that all the territories must now be slave. But almost immediately after the decision, it was rejected. You had Abraham Lincoln travel the country and say we need to ignore the Supreme Court, that this decision is illegitimate. It was wrong. Lincoln ran for the U.S. Senate against a guy named Stephen Douglas. The famous Lincoln-Douglas debates, right, they actually weren't presidential debates, they were senatorial debates. Lincoln challenged Douglas for the Senate. And Douglas said, we need to follow the Supreme Court. We can't start picking and choosing the cases we like. Once we start ignoring the court, everything falls apart. Lincoln said, no, this case is wrong. And we have no obligation to follow it. Indeed, after Lincoln was elected, he ignored it. There were new territories that opened up, and he made them free. He did not make them slave. He ignored the decision. Of course, also, within moments of Abraham Lincoln's election, several southern states seceded. Shots were fired at Fort Sumter in South Carolina, and the Civil War began. So this effort of trying to avert war by simply saying there'll be no more, there'll only be slavery going forward, did nothing. Keep Lincoln in mind and the way Lincoln described whether there's actually a duty to follow the Supreme Court, or whether the president has his own independent obligation to interpret the Constitution. This is a very profound point, and we'll hit this at several junctures. Yes, ma'am. I've been talking a lot. I'm going to stop. Some stuff, I lecture more than often not, but some stuff I want to get out, and this is more useful. So, yes, ma'am. Right. So, and now, thank you, Natalie, for your question. We use this as a segue to the case itself. This case could have been resolved very narrowly, right? If you read the concurring opinion, this case could have been very, very narrowly resolved. Okay. All the court had to say was that because Mr. Dred Scott was not a citizen, there's no jurisdiction, therefore the case is dismissed. Move on. Right? Dismissed for lack of subject matter jurisdiction, right? SMJ. No jurisdiction, no court. But Taney wanted to resolve the issue himself. He didn't want to just, resolve this dismissal now because he feared maybe at some point the case will come back, right? What happens if the case came back from a state court and some state court held that a slave had become free? There was no jurisdictional problem. The court would then have to resolve the underlying issue, wouldn't they? So Taney was not willing to just go half in. He wanted to go all the way in. Okay, everyone okay so far. All right, so who was last time? Who do I have to?
Over here.
Who are you pointing at her?
Was it me or Steve?
I think I called on both of you. I think you're next. Okay. So Anthony, you want to please run us through the facts?
Dred Scott was enslaved by Emerson, and he allowed him to marry a woman, Harry. And they moved from Missouri to Illinois, which is a free state.
Good.
And they lived there for 2 years. And then they returned to, or they went to Minnesota.
Good.
Which is a free territory.
Good.
And then they went back to Missouri.
Good.
And then he filed suit against his owner.
Good. Okay. So I'll come back to you in a second. So the facts of the case were like this. Okay, this is Mr. Dred Scott. He was a slave to Dr. Emerson. Dr. Emerson was a military doctor. And Emerson basically took Scott wherever he went. So he went to Illinois for some period of time. Illinois was a free state. I'll mention this briefly. The reason why, you may ask, why didn't Scott run away when he was in a free state? Under the Fugitive Slave Act, Illinois would have been obligated to return him to Missouri, and he would have been most certainly hung or punished severely. So that's why he didn't just run away. There was a severe penalty at the time. Later on, he got married to Miss Harriet, and they went to Fort Snelling, which is in modern-day Minnesota, north of that green line. So it was in a free territory. The fact that they were able to get married was actually a fairly big deal. You may not even think about it, but marriage is a contract. And slaves were not actually able to engage in contracting at all. So this was actually mentioned in one of the dissents. The dissent said, well, the second they got married, that means that they were emancipated. Probably not, but with their master's consent, they were actually able to get married and have children. Not that they could inherit property or anything, but they had children. Okay, so one child was born in Illinois, the other child was born on the steamboat, right, and the other one was born back in Missouri. At some point, the Scott family was brought back to Missouri, and Emerson died. Okay, what happened next gets a little bit convoluted. The opinion says famously convoluted. Okay, so Paul.
Yes.
So what was the first lawsuit that was brought in this case? The very first lawsuit that was brought after Mr. Emerson died. Dr. Emerson, whatever.
He sued. And
Who sued whom?
Scott sued Emerson.
Well, Emerson's dead. So who did he sue? Who did
State.
No.
The widow.
You guys can't cheat. That doesn't make this very fun. Okay. Yes, you guys are right. It's a team effort. Emerson's widow was sued by Scott, and he sued in which court?
Missouri.
He sued in Missouri State Court. Okay. So in state court, you don't have any sort of jurisdictional issues. You don't need diversity jurisdiction. Anyone, in theory at least, can go. This wasn't in the case, but I think Mr. Scott had some wealthy benefactors helping him out, right? He had people who were trying to get this case litigated, right? They're always pro bono lawyers trying to help out this guy. And he was an interesting case because he'd been transported not just to Illinois, but also to Minnesota. So there were different avenues that he may have been able to obtain freedom. So the argument in state court was this. The moment he stepped foot on free soil in Illinois, he became a free man. The moment he stepped foot in free soil in Illinois, he became a free man. There was a case reference called Somerset's case by Lord Mansfield, Somerset's case. And the case had this beautiful quote, it's very poetic, that the second you take a breath of fresh air in England, right, which was no slavery, you were free, right? You breathe this fresh air and you become free. It's this, it's this beautiful imagery. So Scott's lawyers were like, wait a minute, this guy went to Illinois, free state. But then he came back to Minnesota. So the question becomes this. Under Illinois law, for sure, he was a free man. But is Missouri obligated to apply is Missouri obligated to apply Illinois law? Is Missouri obligated to apply the law of a foreign sovereign? Did I do this right? Or?
Yeah.
Yeah, Zach. Was Illinois obligated to apply the law of a foreign sovereign?
Not according to Amy.
Well, no. What did the Missouri court say?
Oh, no, they're not.
They're not, right? Why not?
Because Missouri was sovereign itself, and because it was within its territory.
Yeah, that's exactly right. So what happened here, right, is Missouri said, wait a minute. I don't care what Illinois says. We disagree. They may think once you step foot on free soil, you're a free man. We don't agree. And we will not apply the law of a foreign sovereign. We are on court. And I note briefly that the Missouri Supreme Court had previously held the opposite. And the Missouri courts changed their opinion, not to be too critical, but they changed their opinion for this purposes alone. Because other courts have said, if you're freed in other states, we'll recognize that judgment. So at that point, there was a decision from the Missouri Supreme Court. The timing of this is fuzzy, right? We don't exactly know what happened. That decision was not appealed to the U.S. Supreme Court. Okay. Had that decision been appealed to the U.S. Supreme Court, this entire business of diversity jurisdiction would never come up. See? But what happened was apparently the widow sold Mr. Scott and his family to someone else, was the brother or whatever, in New York. Okay? They sold it to Sandford. It was a citizen of New York. So Scott's was like, wait a minute, I got an idea, Sheridan. I'm not going to sue in state court. Where am I going to sue? And how am I going to get to federal court? Diversity jurisdiction. You got a citizen of New York, and you have Mr. Scott, who he would say was a citizen of Missouri. He was certainly domiciled in Missouri. But was he a citizen of Missouri? So this is layer one, right? Layer one of the onion. Was Dred Scott a citizen of Missouri for purposes of diversity jurisdiction. I swear, you probably never thought that when you learn about Dred Scott and other schools, it was about diversity jurisdiction, right? Probably never registered in your mind. That's what the case was at a superficial level about. So before I move on to diversity jurisdiction, I want to go back to Article 4 of the Constitution. And we said in Article 4 of the Constitution, there's this clause. And it says, the citizens of each state shall be entitled to all the privileges and immunities of citizens in the several states. Okay. What were these privileges and immunities? There were various rights and freedoms. So there was one case involving a fisherman, right? I think he raked oysters. And I think he was from New York, and he was raking oysters in Connecticut. I might be getting the states wrong, but that was the general idea. He lived in one state, and he was raking oysters in another one. And the state said, hey, you can't rake oysters in our waters, right? This is only for our own citizens. The court, discussed this, and he said, no, wait a minute. Whatever rights are afforded in one state must be afforded to citizens of another state. You can't discriminate against out-of-staters. So the thinking goes, if you're a citizen in Missouri, you get all the rights of a citizen in Illinois. When you travel, vice versa. If this were the case, and Dred Scott was indeed a citizen of Missouri, then he would be entitled to all the privileges and immunities associated with citizenship. But could that be the case? So we move on to the text. Article 4, Section 2. This is the so-called Fugitive Slave Clause. Okay? Let's go down here. A person held to service of labor in one state, escaping into another, shall be delivered. Does that mean if a slave in Missouri runs away to Illinois, Illinois is obligated to deliver him back? So Taney reads this and he says, wait a minute. Is that consistent with citizenship? If a person who moves from one state to another has to be delivered back, does that mean that such a person would be entitled to these privileges and immunities? He said no. So it's really the reason why Taney said they cannot be citizens was because they're not entitled to these privileges and immunities. For if they were, they would not be able to be arrested and hauled back whenever they leave state lines, right? So the first part of Taney's opinion, legally, I'll get to his rhetoric in a minute, but the first part of Taney's opinion basically says that these people cannot be deemed citizens, for they are not able to get these privileges and immunities. Okay? That's the legal argument. But he has a separate argument which can only be described as racist. I don't know any other synonym or any other adjective to provide it. And he basically says if a person is in the United States of African descent, whose ancestors were of African blood, and sold as slaves, they can never be citizens. That no person of African descent ever came here voluntarily. They didn't come here voluntarily, and they cannot participate in our republic. They're not part of our body politic. And he uses some words which are jarring, even reading them 100 and something years later, that they're the unfortunate race, and that they were basically designed to be controlled by the master race. Okay. Now you have to ask yourself, right? Why would Taney use this language, right? I mean, he knew he was being, even by the standards of the 1850s, he was going out there. Like, if you read the concurring dissenting opinions, they don't use that sort of language. Why was Taney going so far on a limb to describe people of African descent in such vulgar language? There was actually a purpose behind it, if I may. The purpose was to dispel any notion that these people could ever be citizens. Think about it this way, right? What happens if New York or Massachusetts or some free state decides, okay, you know what? We are making these people citizens. As a matter of New York law, we are making these people citizens. Therefore, they can go to federal court and sue. Okay? That would screw up Taney's entire compromise. If a state could grant citizenship, that means his entire opinion falls apart. So what Taney has to effectively say is that no state can ever make these people citizens. That because of their very genetic, I didn't know the genetics were, because of their skin color, right? Because of their skin color, they are incompatible with a notion of citizenship and a body politic. That they could never be citizens no matter what one state gives them. And even if a state pretends to call them citizens, they're not citizens, right? A state can give whatever kind of positive rights, they can, this, vote, whatever, on property. That doesn't matter. Because for purposes of the Constitution, right, as a matter of federal law, these individuals can never be worthy of citizenship. Now, Taney had to use such extreme language described in this way so that they can never get these rights. If I can, did you do a proper case called Johnson versus McIntosh, the Indian case? So, do you remember the language that Chief Justice Marshall used to describe the Indians, like these savages, these brutes? For whatever reason, Marshall never gets the flack for that decision that Taney gets for Dred Scott, which I think is unfortunate. The language Marshall used by the Indians was just as bad as what Taney uses here, but we revere Marshall. But what Marshall said in that opinion was the Native Americans are savages. They're not capable of contracting anything. Therefore, they cannot engage in property transactions, right? Blow your mind, right? Why did Marshall use such awful language? To make sure that no state could ever give them the right to contract. If, as a matter of federal law, these Indians were so savage that they could never contract, all the treaties they signed were void. All the contracts they made are void. It's a very similar methodology. To reduce someone to below citizenship means that they can never get it. They can never get the right to transact property. They can never get the right to sue. This vulgar language is used for the sole purpose, not just of dehumanizing them, which it certainly did, but to legally stop them from ever asserting any claim to the body politic, right? That's what Taney was doing here, right? I'm sure he maybe sincerely held these views that Africans, whether he did, sure, fine, whatever. But he had to go out of his way to demean these people as a matter of federal law. Because imagine now you're a freed slave in New York, right? You're a freedman, and you go to court. And you try and file a lawsuit, and you say, hey, look, New York gave me citizenship. I have my papers. I have my emancipation papers, right? The New York court says, wait a minute, I'm reading Dred Scott. They said you're not a citizen. I don't care what New York piece of paper gave you. That, whatever. Paper. You're not a citizen. Get out of my court. You see what he was doing here? He was trying to establish a nationwide doctrine that even if the states attempted to afford freedom to these men and women, they still could not be deemed citizens because of their race, because of their heritage, because they were imported to this country in chains. There's a legal reason behind what Taney was doing. He was not a fool. I mean, he's reviled, but he was still the Chief Justice. He knew what he was doing, and I hope you can at least peel back the layer and see why he used this invective. Now, the invective's there. And it still stings 100-something years later. And it was cited in many different contexts to justify slavery and segregation. But there was a method, right? There was a method to his madness. So everyone get the first layer, the idea of the privileges and immunities of why Dred Scott could not be a citizen. Everyone get that much? No questions on that. It's a very profound point, but I think if you get that, the case makes a little bit more sense. No questions? No? Okay. Yes, go for it.
So, the idea that ambition fights ambition, because that will ultimately result in the best thing. Does that not apply to the courts too? because in this case, the court's being really ambitious, trying.
Oh
to
yeah, they are.
policy,
They are.
You know, and so it seems like the way that we see this case is that no, the courts should not be ambitious. That should be up to Congress and the president. But doesn't the court also play a role?
Luis, how did Lincoln then respond to this decision?
Or he was ambitious too, and he fought against.
He was more than ambitious. He ignored it. He disregarded it. Right.
And so that's just proof of how ambition defeated the other ambition and the best thing.
And we fought a civil war, didn't we, over it? And we had a bloody civil war, brother against brother fighting. And even then, we had Reconstruction. And then we had the Civil Rights era, right? There's a lengthy process, right? This decision put in motion a lot of stuff. So there's a lot of ambition fighting literally with bayonets, right, for the better part of the 19th century.
So earlier in the semester we were discussing how the objective of Supreme Court justice is not to put their own personal ideals and ideologies into the law and the most protects and you gave serious example of that and that's a positive thing. But in reviewing some of the cases and you see that a judge's personal ideology and belief system is what they use to bring forth these laws and these interpretations. So even currently today, when we're talking about Supreme Court justices and electing these Supreme Court justices,
We don't like them. Appointing.
appointing.
Yeah, we don't like them.
And sort of moderates and liberals and conservatives, or it doesn't matter what someone's personal experience is or what their background is. What matters is how they interpret the law. I feel like when we're looking at this history of how the Supreme Court justices have voted or interpreted the law, we see that their backgrounds, their experiences are being brought into how they interpret the law. And so I just wanted to hear what your views are on that.
I'll get to you in a second. But thank you. Very, very, very good question, Natalie. So it's very easy to go through law school and become a cynic, right? It's very easy to go through law school and say, oh, the law is just politics. There's no law there. This is what you taught. We're all realists now, right? I'll push back against that a little bit. I think, and I say this from my own personal experience, but I think all the justices on the current court and in recent years, they sincerely believe what they're doing is the ideal interpretation of the Constitution. They sincerely and genuinely believe that the way they're reading the statute is the way it ought to be read. I don't think there's any justice in the Supreme Court who's acting in a purely political manner and ruling against what they think. But we all start with different first values. Right? We all start from different places. Everyone in this class, we have 80 kids, probably have 90 opinions, right? Everyone in this class sees things differently. And I don't for a second think any of you act in bad faith. I think you're all approaching this as reasonable people who think about things carefully. I mean, if you just want to go on, Facebook and just launch into a screed, whatever, you can do that. I'm sure you will after class, but at least here we can talk. A person's background and what shapes their opinions absolutely informs how they view the law. It can't not. What we would hope for a judge, and to varying degrees, is if they can remove themselves to the extent possible from their prior impressions. I don't think this is possible for everyone. I mean, we all have certain, when I say priors, I mean things that we bring to the table before we get to our jobs, right? I mean, you guys, 90 of you, you came from different walks of life, different schools, different states, different whatever, different backgrounds, rich, poor, black, white. I mean, we all come here with different things, right? So I would hope, at least try, that you can somewhat take yourself out of the situation when you're looking at a legal question, but I don't pretend for a moment that that's 100% possible. What I will note, and I'll get to you in a second, Scotty, is that if you actually look at the confirmation hearings, and I watch these things gavel to gavel, if you actually watch the confirmation hearings of Justice Sotomayor, Justice Kagan, Alito, Roberts, whoever it is, right? They all get up there and say the same thing. Right? They all say, "I will faithfully interpret the law blindly, and I will follow the text of the statute." They all say that. And indeed, there was a big hubbub a couple of years ago when Justice Sotomayor was appointed, where she had written an article where she said that empathy should be a factor in judging. And during a hearing, she ran away from that. She evaded that as quickly as she could. She disavowed that. To use the word of the day. She disavowed it, saying, "No, well, you know, I will faithfully apply the law." So judges always say that. Whether they're actually doing it is another thing. But I want to make it very clear. I don't charge them with bad faith. I think they can screw up. They can make mistakes. I can criticize them. We can all joke about it in class. But I think that all the judges, I mean, not just the Supreme Court, even the federal judges we have, for the most part, I'll caveat for the circuit judges, for the most part, they're all acting in good faith, and they believe that what they're doing is the best interpretation of the Constitution. But maybe I'm too Pollyannish. Maybe I'm too much of naive. Maybe I'm too naive. I don't know. So let me put it this way. So I think the president, when he's making a selection, whoever he or she may be, absolutely can consider that stuff, right? But once the person puts the robe on, right? Once they put on the robe, their oath is to the Constitution and not to whatever predispositions they may have. Whether it's possible, though, this is why I said maybe I'm too naive, is a different question. But I sincerely believe that the 9 justices and the 8 now, I can't count, of the 8 justices and Scalia as well, that they sincerely believe that the way they read the Constitution is the best way. But we can always judge and we can criticize and we can fault. Just as you guys can attack me and I can attack them, we can all criticize in a reasonable manner. But I do believe it's in good faith, which not everyone agrees with. Scott, even patiently waiting, your hands like creeping up.
I was actually lucky enough to go to the same college as Chief Justice Taney did.
Taney,
rather. But what's surprising is he grew up with Quaker tutors and eventually was educated in Quaker, Pennsylvania, which was in the heart of abolitionist territory, being educated in Quaker, Pennsylvania. So the tone of his opinion to me is really surprising, having given his educational background, and he eventually passed the bar in Pennsylvania. That's where he received his legal education. And again, this was deep within abolitionist territory, despite the fact he was reared in deeply divided Maryland, which didn't actually secede when the Civil War happened. It was a Union state.
A slave Union state, that.
So
they booed Lincoln when he walked through the streets of Baltimore.
The tone I find is going to.
Well, Scotty, your point's well taken, right? Taney was not this massive slave champion. He wasn't. But the reason why he used this language, we had to dispel any doubts that the Africans could ever be citizens, right? He had to dispel any possible argument that they could ever be citizens, even by state law. That's what he was trying to accomplish, right? Okay. So that's the first question, right? About the citizenship. And frankly, Taney could have stopped there. He could have stopped there and said, because there's no diversity of citizenship, case dismissed. Case dismissed. But he moved on, right? He moved on to consider the merits. So again, why did he consider the merits? Zulma, why do you think he went on to consider the merits? What was he trying to? Why would he waste and make you read another 20 pages? Like why? This is what people care about. Why did he keep going?
I think he wants to set precedent for the rest of the state, like you said. I think that the opinion that's what he set out to set precedent mostly.
Mm-hmm. What was the precedent he was trying to set?
Besides what we talked about not giving them rights to sue for anything.
Okay. So what he was trying to accomplish, right? What Taney was trying to accomplish was to take care of the follow-up case. At some point, a slave who traveled from a slave state to a free state would come to the Supreme Court with jurisdiction. At some point, right? At some point, someone would have jurisdiction, and they couldn't just, toss them out because it wasn't diverse. Someone would come here from a state court, whatever else, and would have jurisdiction. So we had to then resolve the two main questions. Was the travel of Scott and his family to Minnesota making him free? And was the travel of Scott and his family to Illinois making him free? So we start with Minnesota. Minnesota, right? We start with Minnesota. And the question here is almost surreal. Okay, this, I mean, of all the things that are absolutely insane in the Taney opinion, and there's a lot of insane stuff, this may be the most insane and the most indefensible of the entire opinion. So the Property Clause says, the Congress shall have the power to dispose of and make all needful rules and regulations respecting the territory or the property belonging to the United States. Okay. Heidi, how does Taney read this clause? How does he read this provision of the Constitution? What does he say this provision of the Constitution allows Congress to do?
Control any property.
Any property?
That belongs to the United States.
Which properties in the United States does Taney say can be controlled here?
Well, I was looking at what Minnesota was in the Louisiana Purchase territory.
Does that count for Taney?
I think he said it did, but
He says it doesn't because when they say territory, it only applies to territory that existed
Okay.
at the time when the Constitution was written.
Okay. This, and again, there's a lot of crazy stuff in Taney's opinion, right? There's a lot of crazy stuff. But this is probably the most legally insane thing he wrote in the entire case. He said when they say they can make needful rules and regulations affecting property belonging to the United States, that only affects property held by the United States in 1787. It only controls property held by the United States at the time of the Constitution's ratification. As a consequence, let me go back to my map I showed you a couple minutes ago. All of these lands to the west, all of these lands to the west were not subject to Congress's regulations. All Congress could do would make sure they have a basic government to ensure civil service, but Congress cannot make any rules concerning all the territory out west. Okay? Byron, as a consequence of that decision, that Congress can't make any regulations concerning all these territories in existence after 1787, what does that do to the Missouri Compromise? What does that do to the Missouri Compromise? What was a Missouri Compromise?
It was that Missouri would come in as a slave state.
And no, do you know more than that? What was the consequence of the Missouri Compromise? What's that green line?
Anything south of it would be a slave state.
And anything north of it? So where's Minnesota? North. So what happens to the Missouri Compromise if Congress can't make rules in the territories?
Well, let's avoid that.
The Dred Scott decision ruled that the Missouri Compromise was unconstitutional. Taney went out of his way to invalidate the Missouri Compromise and said that because Congress lacks the power to regulate all these new territories out west, right? The Missouri Compromise was void. And because the Missouri Compromise was void, guess what, folks? Not Montana. Minnesota was a slave territory. That Congress lacked the power to establish any rules concerning this new slave territory. So therefore, when Dred Scott and his family went to Minnesota, it was slave. There was nothing free there. There was nothing free there. Scotty?
On that same token, did you overrule the Northwest Compromise or the Northwest Ordinance as well, or was it just the Missouri Compromise?
So actually, the Northwest Ordinance came before the Constitution was ratified. It actually came before 1787.
So was that?
It wasn't affected.
So, okay.
Good question. So ever get that part of the opinion, right? Minnesota could not be designated as a free territory because Congress lacked the power. Congress lacked that power to make any rules in these new territories. That's a stunning interpretation of the Territories Clause. I mean, he makes all these textual arguments, which are, whatever, but it's a stunning holding. That this narrowly balanced compromise, trying to keep half the country slave, half of it free, whatever. Taney ripped it up. I think I mentioned this earlier. Lincoln ignored it. Lincoln deemed future territories to be free. So Lincoln flat out ignored that holding of Dred Scott as president. But that doesn't address what happens when Mr. Scott and his family went to Illinois. Illinois was a free state. It wasn't a territory. It was a free state. Okay? It was a free state. And presumably, right, states are free, no pun intended, states are free to make their states free. They can eliminate slavery. Scotty mentioned Pennsylvania, Massachusetts, New York. There were a number of free states, even at the time. There were free black men in various states. Okay? So, where is it? Okay, so Scotty, how come Scott and his family's entrance to Illinois did not render them free?
Well, relying on the 28 years before the Missouri Supreme Court had the case, it would have.
I'm past the choice of law issue. But even if, right, even if Missouri court didn't hold that way, let's say another state did, why would Mr. Emerson bringing Scott to Illinois not make Scott free?
You could argue under the full faith and credit clause, Illinois has an obligation to.
No, I'm beyond full faith and credit. What does Taney say of why Emerson bringing his slave to a free state cannot make him free?
Article 5, due process.
Fifth Amendment. Not Article 5.
Yeah.
What does the Fifth Amendment say?
Should not be deprived of property without the due process of law, and by automatically stringing that depriving of them of the due process.
Yeah. So this is another somewhat jarring holding of Dred Scott. Another reason why Taney had to make the African people such a low level was he had to reduce them to property as chattel. Why did he have to reduce them to property? To fit into his Fifth Amendment analysis. The Fifth Amendment says, no person shall be denied of life, liberty, or property without due process of law. What Taney had to effectively argue was that the slave, Dred Scott and his family, were property, the same way you have a cow or a chicken or whatever, right? They were property. If the state wants to take away your property, they have to give you due process and they have to pay you for it. What Taney says was that a provision of the federal government that eliminates, a property right in a slave violates due process of law. This became known, I think I mentioned in class last week, but this was one of the first, not the first, but it was a first prominent exposition of what's known as substantive due process. Substantive due process. Substantive due process is the notion that the due process clause isn't just about procedure, right? It doesn't just mean give someone a trial and that's sufficient. What it actually entails what it actually entails is that there's a liberty interest in owning property. And that no matter how much a process the government gives you, they can't take it away, right? Even if Scott was given a trial, right? I'm sorry, even if Emerson was given a trial, they cannot take away slaves. That this property right was so significant, that this liberty interest, this right to own property was so important, cannot be taken away. Okay, just 1 second. So what Taney held was it would be unconstitutional and violate the Fifth Amendment for the court to deprive Emerson, or now Sandford, of this property right. Okay? But a consequence of this decision is that any state that grants emancipation to a slave would also be violating the Fifth Amendment rights of the master. Think about that. Any master could then go to federal court and say that this state is violating my constitutional rights. What Taney was basically doing here was saying not only is slavery allowed in the territories, but all these blue states, by the way, they're violating due process by taking away people's slaves. And their courts are not allowed to do that. Their courts are not allowed, the courts are bound by the Fifth Amendment. Their courts are not allowed to emancipate because that would be a taking of property. It'd be a deprivation of due process. And indeed, I think I mentioned this a week or two ago. The Emancipation Proclamation was freed the slaves, right? Lincoln. It was done as a seizure of property. The same way you could seize rebel cannons, you could seize rebel slaves. And then Lincoln then emancipated them. And the 14th Amendment had a specific provision saying the government will not have to pay compensation to the masters. This was an entire notion that these people could be sold as property. And Tony was saying taking that away violates their liberty interests. Zach, you're patiently waiting.
Oh yeah, I was just raising. I remember when we talked during Youngstown that Lincoln used that kind of platform.
Truman? Youngstown was Truman.
Yeah, no, I know, but
okay.
We talked about Lincoln and how he used property as like, okay, well now it's wartime powers. I can seize your property, right? And I was just wondering, kind of, did he use what Taney's like? Did he actually quote Taney and stuff, or when he was doing that, or?
You can read the Emancipation Proclamation. It doesn't cite Roger Taney.
Yeah.
But if you read it carefully, it effectively says, as Commander-in-Chief, I'm deeming the slaves rebel property. Right. And I am using my war powers to seize this rebel property. It doesn't use the same sort of language as Taney, but it uses similar reasoning to a point.
I mean, also, I guess we talked about the commerce power and regulating commerce, and since they thought it was property and maybe some sort of economic activity, then they could have regulated. But I guess.
Well, Congress didn't even need that. They had the Fugitive Slave Clause. The Constitution directly gave Congress the power to prohibit runaway slaves. Didn't have to result in commerce. John?
Does that mean that the Emancipation Proclamation was unconstitutional? Okay, so
well, let me answer your question this way. The Emancipation Proclamation was almost certainly a taking of property under prevailing law. There was no compensation, nor was there a hearing. The 14th Amendment specifically said we don't have to pay up. So I think the way I read the 14th Amendment was saying, okay, we probably did something that was illegal. We're going to make up for it now. And because the Constitution was amended, it wiped out those legal claims.
Okay, then my follow-up would be, so what if a slave owner wants to relinquish their due process rights and wants to, relinquish, not have slaves?
Emancipate a slave by himself?
Yeah, but
that was fine.
The only way to do
yes.
It?
It cannot be done by a court.
Not even the president.
Because both the president and the courts, under Taney's reasoning, right? Under Taney's reasoning,
exactly.
Under Taney's reasoning, both the president and the courts are bound by the Fifth Amendment. And for them to take action to take away your property violated the Fifth Amendment. It's a stunning thought when you think about it, right? But this was effectively how and why Taney had to use this degrading language. The same way that Marshall and Johnson said these people are savages. They're not capable of owning property. There's strong parallels there, but Marshall always gets to skip the bill. Yeah.
So since Taney was basing this argument off of the Fifth Amendment, saying that essentially the courts have no power to take away your property, what he's saying.
Yeah.
Even with due process, they can't take. So it wasn't.
No amount of let me put it this way: no amount of process would cure this violation of the Constitution.
Right, because it's your property.
Yes, it's
Right,
such an
so-
important, bundle of sticks, right?
So wasn't he effectively also saying that, well, that whole thing about eminent domain in the Constitution, that's also illegal now. They can't do that. They can't they can't fine you. They can't do anything. They can't take your property at all.
So it's really interesting is that until the 20th century, the federal government almost never exercised the power of eminent domain outside of federal land. And there's actually a really good article by a friend of mine named Will Bode, and he argues, I think, quite persuasively, that the eminent domain power in the Fifth Amendment was only geared towards federal property. It didn't apply to private property. And in a case called Barron v. City of Baltimore, the court held that the Takings Clause did not control the states. And the states had their own eminent domain clauses. So if you had a problem with takings, you go to state law. But the federal eminent domain clause had almost no relevance in the 19th century at all. So, I mean, there was almost nothing on this at all. We'll do Barron v. Baltimore later when we do the First Amendment Corporation. Everyone with me so far, though? There's a lot of moving parts here. So what do we have so right? So first, right, Taney said that Scott can't be a citizen because he's of an African descent. And because citizens are entitled to these privileges and immunities, he can't be a citizen. So he can never go to court. And then he said, oh, by the way, even in the territories, Minnesota, Constitution gives Congress no power over these territories. And then he said, and even in free states like Illinois, it would violate due process of law to remove a person's slaves, right? No hearing can ever do it. You can't just walk in the state, you take a step in a free state. It doesn't work. Everyone get each of the different layers of what he's discussing. Okay? So at the end of the day, what happens? There's no jurisdiction. Scott's case is dismissed. The Missouri Compromise is ruled unconstitutional. The free territories can no longer actually guarantee freedom. Free states can no longer actually help emancipate people. And effectively, the entire a compromise, which was reached by Congress, was unraveled by Taney in what, like 30 pages? The opinion was actually much longer. You only had a snippet of it, but in a fairly short amount of time. All right. So any more questions on the majority opinion? There's a lot of moving parts here. Yeah.
Two questions. First, I assume that everything you said is no longer good law today.
Ha. So not exactly. So let me put it this way. There was one discussion of what he said. About how the provisions of the Bill of Rights apply in U.S. territories. We said, the territories could not prohibit, the right to free speech and the right to freedom of religion and the right to keep bear arms. Remember this part of the opinion? What's really funny is in a case in the 1900s called the Insular Cases, the Supreme Court held that the U.S. territories, like the Philippines and then Puerto Rico and other places, are not worthy of our Constitution. They're not worthy of our constitutional rights. So we're in this bizarre situation. Actually, a friend of mine is leading this case. If you're born in American Samoa, right? You're born in American Samoa. You're given citizenship by statute, but the 14th Amendment doesn't give you citizenship, right? You're given citizenship by statute, by Congress, but not by the 14th Amendment. Why? Because in the Insular cases, they said the 14th Amendment doesn't apply in the territories. That basically they're uncivilized. They're not worthy of our constitutional rights. That was the general gist of the opinion. Go read the Insular cases, right? So much so, there's actually a case in the news last week that you may have seen, which is crazy. Not crazy, but I'll explain why. So it was actually a judge in Puerto Rico, right? And so last year, the Supreme Court held in Obergefell that the 14th Amendment guarantees the right of same-sex marriage. So a judge in Puerto Rico said like 3 days ago, well, good job, Supreme Court, but the 14th Amendment doesn't apply directly in Puerto Rico. Either the Supreme Court has to say it does, or the Puerto Rico Supreme Court rules it itself, or Congress or the legislature passes a statute. But I, as a judge, cannot directly incorporate the 14th Amendment here. And what's perverse, and this is why I'm answering a question with a chuckle, is that the insular cases held the Constitution does not apply in the territories, but Taney held the Bill of Rights does apply in the territories. So it's this weird perverse, and I was actually researching this last night, I guess I anticipated your question, but it's this weird perversity where the only part of Taney's opinion that perhaps anyone wants is that the territories get the Constitution, but the insular cases says no. There's actually a petition pending with the Supreme Court right now that my friend's litigating concerning whether people born in American Samoa are citizens by birth. And he's trying to overrule the insular cases, and we'll see what happens. The court will certainly deny his case, but I'm usually wrong about these things.
Okay, so then the only thing out of that case is actually maybe possibly good law today is that.
Well, it's not good law. In fact, the insular cases reversed it, right? But I mean good law that people actually like. That's the part I'm talking
So
about.
then, no, there's nothing in here.
Let me think. I don't think so.
Okay, I just figured because the way it's pretty absurd. So my second question is then, what is it from this case that we're supposed to take as students, other than on the exam, if you give us the year is 1870 whatever, and somehow we're using
Well,
this case, what are we supposed to take out of it?
What I hope you'll appreciate by the end of the class is how the 14th Amendment attempted to reverse this decision, and how the Supreme Court didn't quite get that far. Dred Scott was a predecessor to the 14th Amendment. The 14th Amendment was aimed at destroying Dred Scott. And the Supreme Court, in interpreting the 14th Amendment, didn't quite do that. Okay. Also, you should definitely take away, Lincoln, right? The way Lincoln responded to this decision is very, very significant. I think I saw a hand up somewhere here. Yeah.
Is this the first case where you see substantive due process, and isn't it still the law?
So this is actually a point of controversy. A lot of law professors say, and it's probably in your book mentioned, I don't agree with this, but a lot of law professors say that Dred Scott invented substantive due process. Empirically, this is false. The notion of substantive due process existed. If you want to go back to Magna Carta, you can go back to Magna Carta, but it was a notion in English courts for many years, and we'll do substantive due process later, but this was a doctrine that had been in existence. It's certainly true this was the first time the Supreme Court applied it in this manner. That's absolutely true, but it didn't create the doctrine of whole cloth. Is substantive due process still good law today? Well, yeah. Roe v. Wade was substantive due process. Obergefell, the gay marriage decision, was substantive due process. Name it. We have an entire unit on it. There are a lot of cases where the courts identify various liberty interests that can't be denied no matter how much process you're given, right? No matter how much process you're given under the law it is now, you can't be denied a same-sex marriage, for example. Any other questions on the Taney opinion? No? Okay. All right, let's move on then to the other opinions. If you notice, the vote was 7-2, right? This wasn't even 5-4. Now, you can look at this two ways. You say, well, this was not even controversial. What's the big deal? It's only 7-2. But the other way to look at it is, I noted earlier in class, that virtually every president appointed for the first 75 years was a Southerner. And it's not surprising that they would appoint the justices who are sympathetic to slavery. Right? Today we think of appointing justices conservative or liberal, but there was a strong sectionalism idea that you would appoint a justice from the South who would, manifest these sorts of decisions. So that was 7-2 perhaps, wasn't entirely surprising, but it perhaps wasn't what you expected. So you had Justice Nelson concurring. And the suspicion was that Nelson's was probably the original majority opinion. And it's fairly narrow, and it only affects whether, in fact, he was a citizen. And it doesn't in the least go into all these insane detours about the territories, the Missouri Compromise, and substantive due process. The Nelson one, it took, like a page to read? But again, had Nelson been the majority opinion, some other case would have come up in a couple of years presenting the same facts where there was jurisdiction, and Taney did not want to duck it. The dissents, one by Justice McLean, the other one was, I think it was Nelson. They reject this. They make a number of points that I think are very important to stress. Taney says, and this part is demonstrably wrong, that Africans can never be citizens. Possible. But what the dissent shows, at the time of the ratification of the Constitution, I think like with 5 states had free slaves. I'm sorry, they had emancipation, right? They allowed to have free blacks. They could own property. I think a few places they could even vote. So what the dissent says, it's simply wrong to say that our Constitution is incompatible with slavery. I'm sorry, it's incompatible with having free Africans. That cannot be the case. Also, the word slave is mentioned nowhere in the Constitution. They say things like held in labor and other persons, but it didn't actually condone slavery. And even if the slave trade was allowed for 20 years, right, that in no way stops states from providing emancipation. Okay. All right. Any questions on the dissents? Needless to say, the dissents didn't get much. They didn't get much attention, right? The dissents tried to make these legalistic arguments, right? But Lincoln said, "No, this is wrong. This is wrong, and we will not follow it. We will not follow it." I discussed the Lincoln-Douglas debates, but this decision with Taney more or less put the Supreme Court in the middle of what became the Civil War. Put it right in the middle. Okay. Any other questions on Dred Scott? Anything on your minds about Dred Scott? Very significant decision. This is not just about learning for the exam, which I'm sure you're all worried about, but these are foundational elements of our American history, which I want you to understand. Far more important than law school. You'll remember this. You'll remember this stuff. But this is important to understand. Yes, sir.
Whenever he talks about striking, basically whenever he says that Congress doesn't apply, any law of Congress doesn't apply to the territories, he also says, but the territories need government. So I mean, he's like directly.
There's this inconsistency, right? You're exactly right.
I'm just curious what government is he referring to. I mean, I know he says the Constitution applies to.
Right. So this is actually, again, why his decision is so troubling. He says on the one hand that Congress can't make any rules in the territories. Oh, but they can have these little governments necessary for whatever society. He's going in circles, right? It's this convoluted thing. I mean, to say that the property belonging to the United States means only the property in 1787, and then say, oh, these rules and regulations, that doesn't mean government. He's tying himself into twisting, pretzel knots. That's why I think your book says, virtually every sentence is wrong or close to it. I won't go quite that far, but there are a lot of wrong sentences in that opinion. But astute point, very good. Anything else in Dred Scott? Nothing? Okay, we'll move on. Very good discussion. Thank you all. The next set of cases I want to discuss are what I call the segregation cases. So we had the Civil War, we had the 14th Amendment, and we have this new provision. And I mean, look, it says, no state shall abridge the privileges or immunities of citizens, right? You can't deprive anyone of life, liberty, or property, and you can't deny anyone the equal protection of the laws. You would think, or at least you would hope, I suppose, you would think that after you amend the Constitution, the Supreme Court would say, okay, guys, we got it. We're gonna ensure that, states don't have segregation, that states aren't depriving people of their rights. You'd think something would change. But for the most part, it didn't. We did one case, Stroud versus West Virginia. You recall that was the case that said the West Virginia law excluding blacks from jury service was unconstitutional. Okay. that was the only case, let's see, until about the 1950s, that the state lost. That was the only segregation case. I might be missing one or two, but I think it was the only segregation case where the government lost. In every other case, the racial discrimination law was upheld without fail. We discussed the civil rights cases from 1883. The court held that under Section 5 of the 14th Amendment, Congress cannot prohibit private discrimination. So you see the chipping, right? So first, the court upheld private discrimination. The next step was in 1896 with Plessy against Ferguson, where the court considered public discrimination. It was during this time that the Jim Crow laws of segregation were emerging. When the South was under Reconstruction, there were no Jim Crow laws. In fact, there actually were African-American people elected to Congress from southern states during Reconstruction. But once the Union armies pulled out and the Southerners were allowed to elect their own government, slowly and methodically, new laws were enacted to disenfranchise blacks, remove their property rights, segregate public buildings, segregate private businesses. Slowly and slowly, this was built up. And the book includes one case, the Railroad Company versus Brown case. It's a short one, but I think it's a good segue into Plessy. Robin, you want to tell us about? Did I do this row last week?
This row?
Yeah. Okay, Robin, you're on hold for now. Sorry. All right. Actually, people tell me I skip rows, so I'm not trying, but occasionally I just skip rows. Sorry. So because the corners. So Travis, what were the facts in Brown, please?
Basically, Catherine Brown. Well, I guess to start off, Congress had authorized this railroad company to expand. Basically, in doing so, they told them, if you expand, we just want you to stop segregating train cars.
Good.
And basically, Catherine Brown purchased a ticket, wanted to get into the car that was appropriated for white ladies.
Uh-huh.
And they refused her and forced her into the car for black women, for African Americans at that time.
Mm-hmm.
And pretty much, she brought suit over that.
Uh-huh.
And in essence, the court held that you can't just pick and choose which parts of that you want to do. If you expanded the railroads, Congress also forced you to remove discrimination from those railroads. And so if you do one, you have to do the other.
Okay, good. So note, this case began in a charter by Congress in 1854. This is before the 14th Amendment, right? This is before the 14th Amendment was ratified. And what Congress basically said was you couldn't segregate. You can't exclude people from the cars on the account of the color of their skin. And this train had two cars, and it said they're comfortable alike. There's one for white ladies and gentlemen, and then the other one for the quote colored individuals. Okay. Ms. Brown sued. Okay, and the court ruled in favor of Brown. And what the court held here was that the colored and white race must be placed on equality. Now, why is this case in your book? This wasn't about the 14th Amendment. The reason why this case is in your book was it was trying to perhaps convey what the Congress at that time thought equality meant. Right? That they thought at the time it meant that public accommodations like train cars could not be segregated. However, as a countervailing point, and I'll mention this when we get to Brown in a week or two, is at the time of the ratification of the 14th Amendment, in the District of Columbia, which was under congressional control, schools were segregated. At the time of the ratification of the 14th Amendment, the schools in D.C., which were under federal control, were segregated. So what does that tell us? We'll talk about that later. Right? There's a lot of contradictions and tensions in this period, and it's often very difficult to try to ascertain what the intent was and what do they mean. But we'll get to that later. So Taylor, let's move on then to Plessy, a case which I'm sure you've all heard of before you got to law school. It's one of the 5 cases people actually know. But let's move on to Plessy.
Facts.
Yeah, facts are good.
So this is in Louisiana, and Louisiana had passed an act requiring segregated rail cars, and Plessy was ever so slightly black. He was like 1/8 black, and he had him and a group of others looking for equal protections kind of conspired to create this plot to get him in court to challenge the law. So they had him go onto a rail car in the lights into the white car where he's not allowed to be. They arrested him on purpose, got him arrested, and took it to court. Where the state courts,
why do you say it's on purpose? What makes you say that?
because they wanted to get into courts so that they could.
Good. Okay, I'll stop right there. So this was a test case, right? We discuss these at a lot of different junctures in our semester. Very often, people want to get arrested, right? Because once they get arrested, they can go before a judge. In Louisiana in 1896, whatever it was, 1895, 1896, they realized they could not get the state legislature to amend their segregation law. So they were hoping sincerely that the U.S. Supreme Court would step in. They had no confidence that the local court would step in, but they were hoping that maybe we put this case all the way. So let me talk a little bit about Mr. Homer Plessy for a minute. There are no known photographs of Homer Plessy. If you Google it on Wikipedia, there's a picture of him. It's not him, okay? I don't know who the heck put it there. It drives me nuts. But we have no, because I found the picture of him, so actually it's not him, okay? We have no known picture of him. We do have a picture of what is probably his tomb. And again, it's not even clear if it's his tomb because a lot of people take credit for famous people when they die. You often see famous people buried in different places, that they'll make a fake tombstone just to bring attention. So I think this is his tombstone, but I'm not sure. And if you go to Louisiana, but I do have his birth certificate though. This is Adolph Plessy's birth certificate from New Orleans Parish. Okay, what else I got? This is the judge, though. We do know who Ferguson was. So, why is it Plessy versus Ferguson? Ferguson was actually the judge who charged him. For reasons that I don't fully understand, the case was actually brought against the judge. The history of the case is somewhat vague. And here's another picture of John Ferguson with his mustache. What's interesting is I actually found his obituary. It says here, the Times-Picayune from 1915. It says Judge Ferguson, retired lawyer, dies age 77. Interestingly, his obituary makes no reference to Plessy. Didn't even reference it. This is the thing. Everyone knows about the guy, right? Makes no reference to the case. I found this article. I'm going to read it to you in a minute. But this was actually the article from the Times-Picayune, I think the day after he was arrested. And it says, in the wrong coach, a snuff-colored descendant of Ham kicks against the Jim Crow law and takes the jail end of it rather than comply with a distinctive provision. I want to read this to you, at least part of it. Yesterday afternoon at 4:15, Detective Kane arrested Homer Adolph Plessy, a light mulatto, and locked up in the 5th Precinct for violating the the Act of 1890. Okay. Captain Kane, speaking of the circumstances, said that he and the conductor had ordered both the man from the white coach into one set apart for colored people. The Negro refused to leave the coach, saying that he had bought his ticket and was going to ride. Captain Kane told him he would either have to retire to their coach or go to jail, to which the Negro responded that he would sooner go to jail than leave the car. Bold. I mean, think about it a second. He could have gotten lynched, right? This is not like a joke. He could have gotten hung on the spot. This was not like an exercise. I mean, they could have just hung him there and nothing would have happened. So he had some backbone, this guy. I mean, the fortitude. So the conductor asked Homer Plessy, "Are you a colored man?" Yes was excuse me. Yes was the answer. Then said the conductor, "You will have to retire to the colored car." The man refusing, the captain was invoked, and he said to Plessy, "If you are colored, you should go into the car separate part for your race. The law is plain and must be obeyed." Okay, then blah, okay, he's arrested. And it goes on. You can read the rest of it later. He was committed to a bond of $500 and released. This tells me that someone was waiting by the courthouse to pay his bond and get him out as quickly as possible so he wouldn't get lynched, and they let him go. This is actually a picture of the East Louisiana Railroad Company. I found this somewhere. And this is actually a photograph of the station. We're not talking about a big train. This is, one of these like 2-car trains that would take people around, these smaller trains. This is actually what the train stop looked like. And this is the order noting that the $500 bond. It says Homer Adolph Plessy. I've done a lot of research on this case. Very interesting history. This is actually Homer Plessy's affidavit attesting that he in fact did refuse to exit the train car. Okay, and this is Mr. Plessy's lawyer, Albion Turget, a great name. And during oral arguments, he very famously asked the justices to imagine if they were black, how they would feel, which is an interesting line of attack. It didn't work. This is the a decision of the Supreme Court, their judgment. This is actually a cool story. So a couple of years ago, the descendants of Plessy and Ferguson, Phoebe Ferguson and Keith Plessy, formed a group trying to promote racial tolerance. And totally out of the blue, Keith Plessy, the great-great-grandson, sends me an email. Because I had blogged about his thing. He's like, can you tell me about this case? So it was actually kind of surreal. I was actually on the phone explaining to this guy's great-great-grandson about his, about the case. It was kind of weird, but it's cool. And we talked for about half an hour. But he was a nice guy. I mean, he wasn't a lawyer, no legal training, and he, I was trying to explain to him actually the details of the case, and he was grateful. So I was happy about that. And this is actually the intersection where his I think is his great-great-great-grandfather. I might be missing 1, 2 greats, but it goes back. Keith was in his, I think, his 40s or so pretty old. Going back. Okay. I can't count that many generations. So, but he's a really nice guy, really interested in learning about the law, and I was happy to talk to him. The job of a law professor never stops. It really doesn't. All right. So, any questions then on the facts of the case? Okay. Your hands up? No. All right, so Lara, how did the court then interpret the 14th Amendment? How did they understand the 14th Amendment in this case?
Basically, they said that it allowed them to be separate but equal.
Mm-hmm.
They could have them separate as long as they were of equal condition.
Okay, but I want you, that's an easy answer, but what I want you to explain is, how does that fit in with the framing of the 14th Amendment? It says right here, the state cannot deny to any person equal protection of the laws. How is separating a white car from a black car not denying someone equal protection of the laws?
Because they were saying that the cars were basically the same, they just were only whites. And
No, you're saying the same thing again, which I appreciate. But how is Homer Plessy not being denied equal protection of the laws?
Because if the accommodations are equal, then how is he being?
No, Robin, your sentence was postponed. But how do you reconcile this with the 14th Amendment? What's the argument why, in fact, they're not being denied equal protection?
I think they're saying because there's a choice that it's not being denied any right. If a white person would prefer to ride on a all-white train, then the same thing on the black train.
Could the white guy get into the black car?
Yes.
No.
No.
And this is a distinction, right? This is an illusion, right? But they said, look, the law is equal. The white passengers can't ride in the black cars, and the black passengers can't ride in the white cars. The law says we separate the races, and we're applying it fairly, and we're applying it equally. Think about just think about that for a moment. They said our law is one of segregation, and we are applying it equally. The whites can't go to the black schools, and the blacks can't go to the white schools. Now, it's a practical matter, right? How many of the whites were breaking down the doors to get into the black car? None, right? Of course, 0. But the argument was equal protection does not mean colorblind, right? That we can consider race However, we can then have separate accommodations.
Okay, when I read the case, I was under I know they made a comment that the basis of them saying that that the Fourth Amendment wasn't violated was that racial identity was in fact a property, is what they said. And they said so by taking away somebody's ability to be around those of their own race, then that would violate the property. That's why they wouldn't touch it.
So Zach, let me ask you a follow-up question, right? What do you think would have happened had Homer Plessy been allowed into the white rail car in 1896?
Then, I mean, if he was allowed in,
Assuming the cops together, maybe assuming while the train was riding, he hopped in, right? You know, what would have happened to Homer Plessy if he'd hopped into the old white car in the middle of the trip?
I mean, he could have been hurt.
I don't think he would have made. I don't think he would have made it to his destination. The argument was, and Zachary's question is a good one. The argument is this: that this law was necessary to preserve peace. Think about it. Just Louisiana said, this segregation is meant for the peace of the races. In order to avert racial strife, and in order to avert these lynchings, we need to protect everyone. I know it sounds absurd, right? But just hang with me for a second. We need to protect the Africans from going into the white car, because if we fail to do so, they're going to get, lynched. This is meant for the protection. You think we're putting you in this black car to subjugate? No, we're doing this for your benefit. Now, right? No one believes that, but this is how the court was actually being sold this. That this was an exercise of the police power. That the only way to keep the races from killing each other was to keep them separate. Right? This is actually how it was being argued. I know people wincing, huh? This is actually the frame in which it was being argued by. Okay? And that's how you get to the separate but equal doctrine. So long as the accommodations are in fact equal, the government has an interest in making them separate. It's not just that they can choose to make it separate, they have an interest in separating the races to preserve this peace and stability on the rails. Okay. Everyone get that, right? It's not just separate but equal. That's what you're taught in grade school, right? That's the easy part of the case. But what they're effectively arguing is that the law is being applied equally. If the law says blacks go to this school and whites go to this school, so long as we're enforcing the segregation rigorously, they're being equally protected. It's literally a protection of the laws that's being applied equally. And they said, look, the 14th Amendment says nothing about color blindness. It says nothing about not considering race. We can do whatever we want. All it says, and indeed, all it does say is equal protection of the laws. And Louisiana argued that is exactly what we're doing. And the court was not willing to step in and second guess that judgment. Indeed, the court takes it one step further. They write that integration must be voluntary and not forced. The court says that social prejudices cannot be overcome by court decisions. The court says if the two races are to meet, it must be natural and voluntary. Legislations can't eradicate racial instincts. The Constitution, the court says, the Constitution is only concerned with political rights, not social rights. And if these groups are socially inferior, the Constitution does nothing to put them on the same plane. And there's nothing in the Constitution that says otherwise, what the majority opinion says. Now, Taylor asked me a few minutes ago, what are we supposed to take away from Dred Scott? Taylor, does that sound familiar, what I just read? What I just read a minute ago. Does that sound familiar? What does it sound like?
Tommy's argument.
Doesn't it? There are so many shades of Dred Scott and Plessy, and I'm glad, that's why I just called on Tyler to recognize that. The argument about the races coming together and fill this up, at least to Taney's credit, he was writing before the 14th Amendment, right? I'm not crediting it, but at least to his credit, there was not a 14th Amendment. Plessy came, 30 years after the 14th Amendment, and they effectively said that the 14th Amendment did nothing to affect the social equality of the races, that all it did was guarantee certain basic political rights. And as we'll see in class next week or after the break, they didn't do much good to protect the political rights either, because the right to vote was basically eliminated for blacks. So despite a civil war and despite a 14th Amendment, the court in Plessy basically fell down. And they said, well, we're not going to do it. Now, I want to not defend the court, but I want to give you a different perspective. That's Katie. Katie, what do you think would have happened in 1896 if the Supreme Court had held that Louisiana must integrate their train cars? And oh, by the way, that means they have to integrate their schools and everything else. What do you think would have happened in Baton Rouge or in, say what?
I mean, like way worse than what happened when they tried to.
Oh, perfect answer. Elaborate.
Riots everywhere.
So in 1960, whatever, in Little Rock, Arkansas, right, when the Supreme Court said you have to integrate your schools, you had literally people rioting in the street, and you had to send in federal troops to escort the Little Rock Nine, these 9 kids, into the building, right? And what happened? The same thing happened in 1896. We've had another civil war. We're like maybe 15 years removed from Reconstruction. These are still people who lived through the Civil War. So I'm not saying this is a defense of the court, but had the court actually ruled in 1896 that you were required to segregate your train cars, and by the way, your schools and everything else, they would have ignored it. The same way Lincoln ignored Dred Scott, the southern states would have ignored Plessy. And don't think for a second that the president in 1890 federal troops back to the South after just ending Reconstruction. So I want you to keep that in your mind as you read the cases for this class and for the next class and the class after, is had the court ruled against the state and ruled that this act of segregation was unlawful, would it have been complied with, and what would have happened? The flip side, though, and let me make this point also very clear, by the Supreme Court upholding these programs, they gave their blessing, right? They're giving their blessing to this form of segregation. It's one thing for the Supreme Court to just not take the case, but to actually take it and rule this way puts its seal, its stamp on it. The same way that Korematsu didn't just uphold Roosevelt's program, it said, yeah, that's great, go for it, right? Dred Scott didn't just, find no citizenship, they upheld it, saying, yeah, slavery is awesome. This decision was like a green light to Jim Crow. Once this decision dropped, Jim Crow was like, all right, let's go. Right? We can make laws like this in every other state. If I remember correctly, Louisiana was, I think, the first or the second state that actually had a segregated train law. They didn't have these laws as much as you think, because we just come out of Reconstruction. So because of Plessy, it gave a green light to basically impose Jim Crow in the American South. So it's a very complicated decision, and I at least want you to understand what would have happened if it came out the other way, but also the consequence of the way in which they came out. Yeah, Tariq?
So how did Brown case affect the state?
None at all. And the reason why is that the Brown case was not an interpretation of the 14th Amendment. It was only interpretation of this act of Congress, this charter. It had nothing to do with the 14th Amendment at all. At all.
And what was the act that was saying directly that segregation was separate?
In the Brown case, the railroad case? In Plessy? Yeah. It was a Louisiana law. No, it was a state law, exactly. Any other opinions? I'm sorry, opinions. Any other questions in the majority opinion in Plessy? Right, it's not just separate but equal. They effectively ruled that so long as law is being applied equally, it could consider race. Right? If they were classifying upon race, that's fine, so long as it was being done equally. And of course, that was a ruse because no white person wanted to go to the black car. And then when Homer Plessy tried going to the white car, he was arrested. Any questions on Plessy? All right, let's move to the dissent. And again, the dissent was by Justice John Marshall Harlan. Harlan was, of course, the dissenter 13 years earlier in the civil rights cases. Sarah, what is Justice Harlan's argument? What does Harlan say?
He basically says that the Constitution
Is what?
is colorblind,
Colorblind, yes.
and that we shouldn't discriminate. And then he goes on to talk about the attorneys.
Yeah, so let's often, right, people have this beautiful image of Justice Harlan when they read his dissent in the civil rights case. And here I am, class playing him up. This is this awesome guy. And then they get to the part of Harlan's dissent. Sorry, my voice is cracking. You get to this part of Harlan's dissent where he discusses Asian Americans and how they're basically not able to be part of the American body politic. So let's get to that in a minute. Let's say Ashley V. What does Harlan mean that the Constitution is colorblind? What is he getting at there?
Basically means that the law shouldn't, I think there was one that the law or the government shouldn't plant seeds to really show discrimination.
Good. Very good point. Very good point. Harlan says the Constitution is colorblind. It does not permit classes among citizens, right? You can't make classifications, blacks in this car, whites in this car, whatever, right? But it's not just about being colorblind for the sake of being colorblind. Ashley raises a very fair point. When you have a segregated train car, or when you have a segregated school, that sends a very clear message to other people. Right? Imagine you're a little kid walking around in New Orleans. And you see, oh wow, these people go to this car, and those people go to this other, lousy car. Those people must be worse off. The act of segregation wasn't merely about separation. This is one thing about Jim Crow people don't necessarily understand. The act of segregation wasn't merely about separation. It was about subordination. It was about showing that these people indeed are subhuman, and they get their own rail car and they get their own school because they're worse. So what Harlan says is by giving this stamp, what he calls these badges of inferiority, right? These badges of inferiority, you're effectively branding someone as less than human. And that's something that children see, and they grow up and they perpetuate it. So the Jim Crow wasn't just about separation. It actually to do with subordination, to actually subordinate people. Is a very systematic and deliberate effort to accomplish this goal. And Plessy gave it the green light. Indeed, Harlan even says, and this is a Taylor's question before, this is an awful lot like Dred Scott, right? Harlan's saying, like, this reminds me of Dred Scott. This is what we fought a civil war to fight over. Okay. So that's the first part of Harlan's dissent. And I think I mentioned this in class a week ago, but Harlan actually lectured on constitutional law, and one of his students transcribed his notes, and I had them typed up. And he would talk about this point for hours. He would always talk about how awful Dred Scott was, and how the 14th Amendment was meant to reverse this decision. And he lamented so much the Plessy case. This one broke his heart. But then in the part that usually makes students wince, he says, however, there is a race so different from our own that we do not permit those belonging to it to become citizens of the United States. I allude to the Chinese race. They are absolutely excluded from our country. Now, the anti-Asian animus, well, alliteration, the anti-Asian animus we saw in Korematsu didn't spring up out of nowhere. especially on the West Coast for much of the 19th century, there was a strong suspicion that people of Asian descent could never become Americans. Why? Because they were always loyal to the Emperor of China or the Emperor of Japan or whatever happened to be, whatever country they were from. And Harlan embraces this fully. And to Harlan, and this is something he echoed in his lecture notes, the Civil War was not fought about liberating Asians. It was fought for liberating blacks. And he sincerely believed that. And he sincerely believed that Asians could never assimilate into our country, whereas he believed African Americans and the freed slaves could. So it's a weird contrast where in this, foundational decision, this dissent that's supposed to be this, the shining example on the hill of a colorblind constitution, Harlan, deviates into this anti-Asian animus, and I make no apologies for it. I mean, it's pretty awful, but he sincerely believed that Asians were on a different plane than blacks. Okay. Okay. So, any questions about Harlan's dissent? Any question on Harlan's dissent? So where do we go from here? Okay. After Harlan's dissent in civil rights cases, we'll do a few cases way next week after we get back from spring break. We'll do a few cases. And in each case, a various provision of discrimination is considered. One shutting down a black school, another denying blacks the right to vote, various manifestations. And what I want you to keep in mind when you read those cases is how the court avoids citing Plessy. How the court avoids reaffirming the doctrine of separate but equal. They find different ways to rule in favor of the government, that is, to oppose segregation, without embracing Plessy. And that is done very deliberately to avoid giving more weight to this decision, which Harlan and others came to detest very grossly. Any questions? Have a wonderful spring break. Thank you.